All right, ladies and gentlemen, I'm back once again to discuss Chapter 8 of our textbook. I'm Professor Brenton Boyce. I'm teaching courtroom testimony. Our textbook is Winning Courtroom Testimony for Law Enforcement Officers, The Law, Art, and Science of Effective Court Communication by Matthew J. Medina. So right now we're going to discuss Chapter 8 of this textbook. Now let's go ahead and jump into it. Chapter 8 is the first chapter in Section 2 of the textbook. And it opens up, the second section of the textbook is all about direct examination. So this is essentially discussing the how-tos of answering direct examination questions. As we said before in earlier chapters, direct examination is when the litigant party that is calling you, that asks you to be there, um, is putting you on the stand and they're asking you questions first. Now, there are certain rules that apply to how they can ask you questions. We're not going to necessarily go into that a lot. Now, they have to ask you what we call direct questions. They cannot ask what we call leading questions, and we'll get into what a leading question is. I'll go ahead and explain it. A direct question is a question that elicits a response, essentially a yes or no or direct answer. So if I say, where were you on the night of September 1st, 2020? That is a question uh, that just requires a response. That is a direct question. Now, those are the types of questions that can be asked on direct examination. On direct examination, the litigant is not allowed to ask you leading questions. Now, I know you want to ask me, what is a leading question? A leading question is a question that suggests the answer in the question itself. Now, the example of the first question I asked was, where were you on the night of September 1st, 2020? Right? That's a direct question. I'm going to ask that same question, but I'm going to ask it in a leading manner. On the night of September 1st, 2020, you were at Havana Field Cigar Bar, weren't you? Now, you see how in the first question, I asked him as a direct question, and they essentially had to give me the answer, as opposed to me telling them where they were in the question itself. I kind of pushed them to the answer, right? So if I ask the question, if I say, weren't you at Havana Field Cigar Bar on the night of September 1st, 2020? That is a leading question. Or on the night of September 1st, 2020, you were at Havana Field Cigar Bar, weren't you? And you were with a friend, weren't you? You were lecturing for your courtroom testimony class, weren't you, Mr. Boyce? Those are all leading questions, and those are generally not allowed during direct examination. So if I'm calling my witness, I can't question my witness like that. So the only time I'm allowed to question like that, if I'm a litigant, is if it's doing cross examination. That means I'm questioning someone that has been called to come to court or has been already been questioned on direct examination by the opposing party. So now I'm examining them, so I can ask them leading questions. Now, the only exception to the no leading questions during direct examination rule is if I ask permission from the judge to treat the direct examination witness as a hostile witness. I know you're like, well, why would you ever treat a person you're calling as a hostile witness? Let's say, if I'm a prosecutor, a lot of domestic violence cases, right? You have a male and a female, and we don't know who. Let's say the victim is the male, right? And the victim has been summoned to court. They have to come to court, and the victim comes to court, and now the prosecutor, I want to prosecute the case. I feel like I have enough evidence. I have an earlier statement that the alleged victim gave, and I want to prosecute. But the victim now is back with his girlfriend, and he no longer wants to prosecute. So he's not willing to come into court and give me testimony. He's like, "Will you please dismiss it?" I refuse to dismiss it. Now he's peeved at me, right? So we have to go to. I've decided to go to trial, and he's subpoenaed to be there. So I got him where he can't leave. So I know he's going to be a jerk on the stand because he doesn't want to be there. So I ask him questions. He gives me attitude. and I know he's not gonna. I'm gonna have to pull things out of him, right? So at that point, I can now look to the judge and say, Your Honor, may I have permission to treat this witness as a hostile witness? In that situation, the judge would have seen what you're seeing, and they'll see the responses and how the person's acting, and more than likely, the judge will give this person permission to treat that give me permission to treat the witness as a hostile witness. In that situation, now I can treat that witness, even though I called them, as if I'm cross-examining them. Also, this may happen in the middle of a case. Let's say if I'm a defense attorney and this police officer has already taken the stand, and I might have already cross-examined him, right? But then something comes up later, and I realize this police officer may have further evidence that can actually help my case. So now I want to call him in my case on direct examination, and the police officer, even though he spoke, I'm teaching you guys to be fair and impartial, but he may not want to be. I ask him questions and he's acting a certain way, and I can say, Your Honor, do I have permission to treat him as a hostile witness? And sometimes just because of the fact that the police officer is already being called for the opposing side, and now I'm essentially flipping him and calling him on my side. Sometimes I can just open up and say permission to treat him as a hostile witness, and the judge will understand. The judge, having been there and during the trial, would see that and give me permission. And now I can ask this person um, leading questions on direct examination. But that's the only exception to that rule. Otherwise, an attorney can only ask direct questions and not leading questions. So leading questions are only for cross-examination or in the situation during direct examination when a witness has been classified by the court as a hostile witness. So those I just wanted to lay that groundwork. Now that it's going to matter a whole lot to your testimony, because you're just here to answer questions, right? So overview. Oh, well, we've already talked about. Okay, so section 2 is about direct examination. So chapter 8, precision and simplicity. You want to be precise and you want to be simple and quick. Give quick, precise answers. The first step to being understood is to choose simple and precise words. Whenever you can decide between using a big word and a small word, use a small one. Sometimes this will not be possible, and you may have to use a big word because that's the only word to explain what's happening, right? But when you have the choice between simple phrasing and complex phrasing, always choose simple. This does not mean that you dumb down your testimony for the jury to understand. You never will treat jurors like they're stupid, right? Of course, that will always backfire. Jurors won't like you if you're acting and answering questions like, and I said, you're talking like they don't speak English or something, or like they're just, stupid. So if you do that, it's a jury, we talked in earlier chapters about the jury kind of, needing to kind of like you to kind of believe you, right? So if you do something like that, you're automatically a jerk, and now they don't care what you say, they don't believe you. So you don't want to dumb it down and treat them like they don't understand. Now there's a difference between ignorance of what's going on and stupidity. So you want to speak. So you may be speaking on a highly technical matter, right? Where these people may not understand it, but it doesn't mean you talk to them like they're stupid. Okay, there's a difference. So use simplistic and precise language, but don't dumb it down. That could backfire. The book says to treat jurors like they are intelligent people. As I said before, ignorance is not the same as stupidity. And jurors will not like it if you treat them like dummies. It is easy to strike a balance if you just answer the questions posed to you the way you would answer an intelligent friend if he or she asks you questions. If you're in front of one of your good buddies, and that person's intelligent, or a regular person, one of your friends, and they ask you a question, how would you answer? Just that's how you answer a question in court. However you would answer that person. Just precise and simple. So the book has some examples of questions, and in your reading of the chapter you'll see those. The book has a line of questioning to an officer. You approach the driver. Yes. The window is already down. That is correct. The driver did not attempt to flee. No, he did not. You see how those, so in that situation, it's almost like the litigant in the questioning there in the questions they're asking, they're kind of telling the story with the questions, and all they need is a yes or no to confirm it from the person, and that's actually a good line of questioning from the litigant. And if you're going to, as a litigant, of course, I'm not teaching this class for litigants, I'm teaching this class for witnesses. But as a litigant, if you design your questions a certain way, you just get yes or no responses, and it's almost like you're telling the story, and they're just saying, "Yep, that's what happened. Yep, nope, nope." You know, so that's what you want to do. The police officer in that example I just said provided short, simple, direct, and appropriate responses. Short answers are generally better than long answers. This is especially true when you answer questions under cross-examination. Notice that the officer answered questions asked and only questions asked, didn't add anything to it. You do not want to add anything or make gratuitous comments to yes or no questions. Now, but you don't want to answer, if you answer a vague question or you answer a question vaguely, you want to explain what you mean. So an example would be an example question. When you attempted to place handcuffs on the defendant, what did he do? And the answer is the suspect refused to comply. So we know that seems simple enough, but in a case where you're trying to see specifically what a person did, the suspect refused to comply is not necessary. It's kind of vague. It doesn't tell us exactly what they did. So tell us what he did. So don't so, and if you say he refused to comply, a lot of times, because the litigant and ask you the question will say, well, how did he refuse to comply? Then you can answer. But rather than giving a vague answer, just say what he did. Yeah, he jumped out of the car, and when we tried to put him in handcuffs, he wiggled away and tried to run. That's more specific. So it's not just about being simple, but it's also about being precise. So you want to be both. So you don't want to be so simple that you answer questions vaguely and you don't give us all the information. Give precise answers to open-ended questions, especially when the questioner is being asked on direct examination by the prosecutor. So, just to wrap up chapter 8, this is kind of like the bullet points they give. Favor simple words and phrases over complex ones. 2, favor short and direct responses within reason and never sacrifice precision. That means if you have to give a longer answer in order to be precise and to be detailed, give the longer answer and explain yourself. Never give vague answers and just leave them out there. And normally the litigant who's asking you questions won't if there's a vague answer, normally the litigant is going to ask you a follow-up question to get you to explain more. So he didn't comply. What does that mean? How did he not comply? But sometimes you can just let the litigant do the questioning instead of doing it yourself. But in that situation, of course, you won't. Let me see. In that situation, you rather just answer it precisely the first time. Of course, avoid using jargon or cop speak. So you don't want to use that. Yes, and I got on my 1035 radio. I radioed into 1045, and you don't want to talk cop language because regular people don't understand cop language. So don't do that. Avoid using slang. Stay away from big scientific sounding words if you can. Now, if you are testifying as some type of scientific or expert witness or forensic specialist or expert, you may have to use some words. But just be prepared to explain what those words mean. So, use words and phrases that come naturally to mind. Ones that you would use if you were telling a story to an educated friend. When favoring the simple, remember also do not talk down to the jury. You want the jury to like you. At least if they like you, they're more likely to believe you. So that is chapter 8 in a nutshell. Once again, at the end of chapter 8, you got those questions, like at the end of every chapter. You can see I've already highlighted them. And then when you turn the page over, look at that. You got the answers to the questions, right? So if you do that for every chapter, you'll be prepared for whatever questions may come on the quiz from chapter 8. So just remember to do that. But that is chapter 8. You guys take care.